This is Colin O'Keefe for LXBN TV, and today we are talking about Zynga, and in particular litigation claiming that the company may have completely stolen their popular Facebook game, Farmville. To discuss this litigation and Zynga, we bring in Scott Schaefers, partner at Seyfarth and author on the firm's blog, Trading Secrets. For those who aren't familiar with Zynga and Farmville, Scott, can you explain the basics of this case? From what I've read, Zynga, may not have the most morally sound practices when it comes to developing games.
Hi there, Colin. Thank you for having me, and it's our pleasure to work with you and answer your questions. I can speak to what the judge's opinion said about a week ago. I think it was February 3rd when it came out. Mm-hmm. This is what plaintiff has alleged, and this is what the judge has found so far. Plaintiff alleged that SocialApps is the plaintiffs. They have alleged that they created myFarm. Mm-hmm. I think they launched it live, in the end of 2008, something like that. When it exploded with popularity and everybody started using it, Zynga comes along and speaks to SocialApps and says, you know what, let's talk about an acquisition. We can expand the myFarm application, and we can really take off. So the two parties signed a written non-disclosure agreement while Zynga conducted its due diligence, which is investigation into the acquisition. I believe the agreement was signed on May 19th, 2009. I used the month and the day, which is quite a bit of detail, but for this reason. Less than a month later, SocialApps alleges, Zynga came out with what we all know to be Farmville on Facebook. And within a month after receiving the source code, after receiving a lot of the other images, concepts, and features is what SocialApps alleged. Zynga just turns around and started its own Farmville virtual farm app on Facebook. And so SocialApps sued, alleging 8 or 9 or 10 causes of action. And just the other day, the judge issued a decision, a very interesting decision, in which she kept alive a lot of SocialApps' claims.
Yeah, it's interesting to watch, and this is a very unique situation. Zynga has been criticized for these types of things before and continues to be criticized for these, but with this, it's very unique in the sense that Zynga had direct access to their source code. They can take a look at all the guts of the program, but do these other companies that I've seen who don't have previous contact with Zynga, but they do have games that appear to be copied, do these other companies stand as good of a chance as SocialApps does of defending their intellectual property?
Well, Colin, before I answer that, I do have to make one thing clear. I don't know about Zynga's other claims. I don't know about its practices. I can't comment on them. I don't want to be put in a position where I'm churning out rumors that might not have much of a basis. But I'll tell you what I know in the context of the judge's decision last week. The judge said the only thing that the judge dismissed last week is the trade secrets claim that SocialApps brought against Zynga based only on the features and the images of Farmville. And the reason that she dismissed those is because the images and the features are online.
Yeah.
It can't be a trade secret if it's online, said the judge. So to the extent that other companies have similar claims, similar issues against Zynga, and to the extent they're trying to sue Zynga or claim that its images online, certain of its features which are readily accessible online, are trade secrets, are confidential information, they'll have an uphill battle in that respect.
I see.
Okay? But what's interesting, if it's okay, Colin, I don't know if you want to ask another question. I was going to talk about what other companies might find useful in the judge's opinion last week. The judge said, and it's two parts of her opinion are very interesting. The first part is that, yes, Zynga and SocialApps in May of 2009 had this written non-disclosure agreement, right? Normally, in contract law, parties and nations to not use information, to use information, are spelled out in that agreement. And there are a lot of courts across the country that would tell a plaintiff like SocialApps, you know what, you don't get to allege these claims, for example, of breach of implied contract. breach of implied covenant of good faith and fair dealing, which SocialApps did. You guys had a written agreement. That's all I'm going to look at, says the judge, or would say the judges in a lot of other states, a lot of other jurisdictions. And so you don't get to pursue these breaches of implied contract and this breach of confidence claim that you had, right? The judge in the SocialApps case didn't do that. Mm-hmm. She said, okay, SocialApps, I'll uphold your breach of written agreement claim, but I'll also uphold your breach of the spirit of the agreement, in essence, that no matter what the written instrument says, you had an implied understanding, you might have had handshakes on the side, you might have had discussions on the side where SocialApps and Zynga representatives knew what was going to happen, what was not going to happen. Mm-hmm. To the extent that Zynga may have breached those, according to SocialApps, the judge is going to hold Zynga to those implied understandings.
I see.
And that's a very interesting part of her decision.
Yeah, I mean, it's going to be interesting to watch with Zynga. It's a company that, because they don't have the resources that other companies have, they're selling a digital commodity, so they're almost, I mean, with the revenues that they're turning in, they're almost printing money. They're on the cusp of an IPO, and a substantial portion of Facebook's revenue comes from Zynga, or not an inconsequential amount, but, you know, with this type of thing looming out there, how much damage can litigation do to a company like Zynga?
Well, a lot is the answer. A lot of damage, because I don't. And again, let me just emphasize that I only know as much as the complaint in the SocialApps case and the opinion revealed to me. So I don't want to be seen as churning out any rumors that might not be 100% true. Mm-hmm. But litigation, especially intellectual property litigation, especially for these Silicon Valley companies like Zynga, like SocialApps. Remember, the decision came down from Oakland, California, the heart of California, Silicon Valley. That's the meat and potatoes of their business, are these apps, right? And these lawsuits, plaintiffs, if successful, can get the damages, the lost profits. They can get royalties under the Trade Secrets Act. They can get attorney's fees if they show that the conduct was what's called willful and malicious, that it was a total betrayal of the trust and confidence placed. They can get punitive damages as well, in California at least, up to 3 times of the damage amount. And so it can be pretty crippling, not to mention the fact that litigation, unfortunately, takes a while, and in the meantime, you're forced to pay attorneys, work with attorneys, sit for deposition, produce many of your documents. This intellectual property litigation, it can be pretty damning to a company like Zynga.
Yeah, it's gonna be very interesting to watch. You know, as I said, this Zynga is a big company, and it's producing a lot of products, and it's producing a lot of money, and it's on the cusp, like I said, of an IPO. So it's going to be interesting to watch.
Colin, can I add one more point about what was interesting about the judge's decision?
Yeah, go ahead.
I hate to take any more time than we have, but one interesting thing about the judge's decision is her upholding the SocialApps' breach of confidence claim. And the reason that that's interesting is because under a lot of cases in California state court cases anyway, not federal courts like the court that issued this decision February 3rd, a lot of state courts in California might tell you that if you make out a trade secrets claim, a statutory trade secrets claim, you cannot make out any other what's called a common law claim, like a breach of confidence, based on the same set of facts. But the federal court here, she said, no, that might be down the road sometime. For the time being, I'm going to allow SocialApps to proceed with this breach of confidence claim. And just to wrap up very quickly, what's interesting about that is that the judge effectively set a mid-level cause of action for SocialApps. Mid-level meaning between a statutory trade secrets claim, which is up here, and no claim because the information is in the public domain down here. There's a mid-level there that the information that was allegedly stolen does not have to rise to the level of a statutory trade secrets claim in order to be protected and in order for SocialApps to collect damages on it. So that's a very interesting development in California law, which has not gone resolved by the California Supreme Court. and which the California courts are fighting over to this day. So it's interesting that the judge in SocialApps did that.
Yeah, that will be interesting to watch. It's very interesting. Once again, that was Scott Schaefers of Seyfarth Shaw. For more on this developing story and the intersection of software and copyright law, be sure to visit tradesecretslaw.com and lxbn.lexblog.com. Thanks, Scott.
Thank you, Colin. Good to see you.